If you call North Carolina home, you know that our state is rich in natural resources. In certain areas of the state, those resources are underground as well as above. Now, you've probably heard about state laws passed in 2012 regulating oil and gas exploration. New technology allows extraction of natural gas from previously inaccessible deposits underground using a process called hydraulic fracturing or fracking. Real estate brokers, buyers, and sellers need to know about fracking and the required disclosures that will be in your real estate contract. So, what is fracking and how does it work? Fracking starts with drilling a deep well down into the ground, hundreds or even thousands of feet below the land surface. Then the drilling moves sideways, stretching as far as a mile. Water and chemicals are pumped through the well at high pressure. This is what fractures the shale rock, releasing the natural gas. So how does this affect your real estate transaction? Well, it's possible for a company to own oil and gas rights underneath the property, while someone else owns the land on top. In this scenario, when the owner of the surface property decides to sell, the oil and gas rights are not included because they belong to someone else. This means that the buyer will own the surface property, but not the oil or gas that might be below. Suppose you want to buy a particular property. You might want to know whether it includes the subsurface rights. State law now requires most sellers to disclose this in the sales contract. This disclosure cannot be waived. Are there transactions where no disclosure is required? Well, sure, a few. The exceptions to the disclosure include court-ordered and estate sales, sales between co-owners, and lease with option to purchase contracts, but only when the tenant occupies the property. Now, another important exception to the disclosure requirement is vacant land. The new law just doesn't address it. If you are buying land or you are a broker representing someone buying vacant land, you should investigate whether the property includes oil and gas rights. Unless a real estate sale is covered by one of the exceptions, Chapter 47E of the North Carolina General Statutes requires the seller to answer 3 specific questions in the real estate contract. 1, have the oil and gas rights been severed from the property by a previous owner? 2, has the seller personally severed the rights from the property in the past? And 3, does the seller intend to sever the subsurface rights from the property prior to closing? Now, what if the seller doesn't know whether or not the prior owner separated the gas rights from the property? The seller can make no representation about what the prior owner did. In that case, the buyer should have an attorney assist in checking the land title records for more information. Now, even though a seller is allowed to make no representation about what a prior owner did, the seller must disclose whether he or she personally severed the subsurface rights or intends to do so prior to closing. If you have questions about fracking, there are a lot of great resources. You can find bulletin articles on our website under Publications. You can read the new fracking law on the General Assembly's website by searching hydraulic fracturing. And to see a CNN video, go to YouTube and search CNN Explains Fracking.